Namaste, welcome to the session number 5, recording session number 5. Here we will do what it was planned to do during the session, reading comprehension. Once again, I know you must be feeling that it is repetition, but again, at the cost of repetition, I would like to say that four basic principles of any language would be listening, speaking, reading, and writing. One needs to master over all four, and then only you can say that yes, there is a proficiency, there is a mastery over a particular language. Right now, we are talking about English. So, first, reading comprehension, when you are doing it, the benefit of that would be first, you have to read it properly. Then you start speaking inside your brain, inside your mind. You start talking to yourself કે આ પેરેગ્રાફમાં આવું કહેવા માગે છે. You will start conversing to yourself. Now you know what is conversation. એના પછી you will read it again, reread થશે, and then you will derive that okay, this is the exact answer from this passage. આમાં આવું કંઈક કહેવા માગે છે, and you will note down the point. So, and then whatever you have written, you have to speak. During the session also, I request and I prefer that if all four can be done together, તમે બોલો પણ ખરા, તમે સાંભળો, which is already there, read and then write. If all four can be done together, then it is very, very easy to do so. Now I'm sharing here the reading comprehension for those who are not having the hard copy or who have not yet get time to go through it. Here it will be shared. I hope it is visible on the screen. I can see it on the screen. Yes, I guess it is visible. The first paragraph, the first passage is about contract law basics, basic contract law. Here, I just request, it is not about knowledge of law, knowledge of contract, or knowledge of any other topic which would be there in the passages, because that is your forte. You already know about it. What here we are discussing, or where we are focusing while doing this, is language and not the law. So here the first passage is about contract. Suppose the first question from the comprehension, from this passage only, maybe you know more than 4 pages when you have to speak about the basics of contract. But dear sir and ma'am, mess them. Remember the plural of madam? It will not be about the knowledge of contract. It is about the passage that is given and question that is asked on the basis of given passage. So the first question says that what are the essential elements of a valid contract? તમને બધા જ એસેન્શિયલ એલિમેન્ટ્સ ખબર હોય, આપણને આ પેરેગ્રાફમાં આપ્યા છે એટલા જ આપણે જોવાના છે. It is direct question that offer acceptance, consideration, capacity and legality. અત્યારે આટલાની આપણે વાત કરવાની છે, as it is already given in the bold in second paragraph, as you can see. That is the answer for it. The main thing is, what is the tense of this first question? The tense of this first question is simple present tense, and our answer is also in simple present tense. જેટલું પૂછ્યું છે એટલું જ, એનાથી વધારે કશું જ નહીં. Second question, why does the term consideration mean, what does the term consideration mean in contract law? Consideration mean in contract law as per this passage. આપ જાણતા હો એની વાત નથી. This is simple present tense and answer is consideration refers. કારણ કે કયો tense છે? What does? Simple present tense answer માં આપણે એ જ tense રાખીએ છીએ. Consideration refers to the exchange of value between the parties, such as money, goods, services or a promise, as it is given here. અહીંયા જે સેકન્ડ પેરેગ્રાફની સેકન્ડ અને થર્ડ લાઈનમાં આપ્યું છે, અહીંયા જે આપ્યું છે, we have to derive from that, right? Third, why might a contract with a minor be considered invalid, right? Why might a contract with a minor be considered invalid based on this paragraph? Because minors typically lack the legal capacity to enter into a binding contract. because they need a major, they need a guardian to enter into the contract. They need the major to accompany them to enter the contract. That's why it starts with because. You can start the sentence with because in the field of law. Otherwise, linguistically, it is considered a vague answer. But in the legal field, you may start it with because there is no vague, there is no ambiguity, it is perfect, it goes with the linguistic aspect as far as legal language is concerned. After that, it is what is the purpose of the statute of frauds as per the paragraph. As it is clearly given in the paragraph number 3, you can read it is statute of frauds. I have already highlighted, it is in bold letters. That to require certain types of contract, sorry, I'm just reading the fourth one. To require certain types of contracts like those involving real estate or long-term agreements to be in writing for enforceability. This is how it would be into consideration. I think there was some issue in connection. I hope I'm audible. Okay. And the last is name two possible remedies for a breach of contract. તમને વધારે આવડતી હોય, here from the passage we have to take any two as it is given in the last paragraph, that second last if we don't consider the last two lines, the damages and specific performance breaching, and into bracket the already specific performance, into bracket the another details are given. As I said, when it is in the field of law, as you all are familiar with the term brief લેવાની છે, બેઝિક વર્ડ્સ ઉપર જ કોન્સન્ટ્રેટ થવું જોઈએ and not on the whole sentences or statements until and unless it is the question that is inferred. આ પેસેજમાં બધા questions direct જ હતા, so there is no issue like that. Just a minute. Okay. So here we go with the second paragraph, that is about the principle of legal precedent. I just request you may just go through it, or the best idea or the best technique for doing reading comprehension when you have to read and some questions are there on the basis of that. The ideal technique is first go through the questions, go through the notes, and then read the paragraph. Then do rereading as per the requirement, not the whole paragraphs. નહીતર પછીનું વાંચો એમાં પહેલાનું, it may get skipped. Human brain also has certain limitations, that's why. Suppose, why is legal precedent considered essential in legal system? What is the tense? It is simple present tense. Clear answer આમાં આવી રીતે આપેલો છે? No. આની પહેલાના પેરેગ્રાફમાં જેમ ક્લિયર ડિરાઇવ્ડ ક્વેશ્ચન હતો એવું નથી. You have to infer the answer of this question. Sorry, first question is direct like the earlier paragraph. As it is said that legal precedent considered essential in a legal system. So, excuse me. It is to promote the consistency, predictability and fairness in legal decisions. As it is clearly given, you just have to copy it from there, right? It is clearly given in the very first paragraph and it has to be taken just like that. Second question, it is inferred. Inference કરવાનું છે. If a lower court encounters a case with significantly different facts from a prior ruling, what might it do? પહેલાનો જે કેસ છે એના કરતા ઘણું બધું અલગ છે. Then what it has to do? Simply based on the content given in the paragraph, આનો answer એવો થાય કે it might, because the question asks what might it do? What might it do? It might distinguish the case and apply a different legal principle. Means પહેલાના કેસમાં જેવો પ્રિન્સિપલ લાગુ પડ્યો છે એવો આમાં નહીં પડી શકે because the facts are different. લાગે છે એવું in first prima facie એવું લાગે છે કે this is like a prior case but it is not. Then different principle can be applicable considering it because that is the legal precedent. That is the principle of legal precedent as per this paragraph. Right? Next, as it is said, why might a high court choose to overturn its own precedent? ક્યારે એવું થાય કે હાઈકોર્ટ પોતે જ પોતાનો own precedent overturn થાય? Here, to adapt to change in societal norms, legal interpretation or policy consideration. એક તો સૌથી પહેલા societal norms change થયા હોય પહેલા, say for example earlier live-in relationship was not having legal backup. Now it is having legal backup. Now live-in relationship is legal. So that is societal norms change thaya che. Say for example, legally it is allowed, but do you think that in society people are welcoming live-in couples at large? No. So it has to be based on the societal norms as well. Legal interpretation, whatever was the legal interpretation of the law in 1964, will it remain the same in 1994 or in 2024? No. So that has to be taken into care. Or policy consideration. Say for example, some new policy is introduced. It is right to education. Earlier when it was not launched, the scene was different, the scenario was different. After right to education, the scene and scenario is different. So in that reference, the answer is given. After that, how does societal change influence the application of legal precedent? Again, this is not direct question. So societal change can prompt courts to reconsider the established precedents, especially when past ruling no longer align with contemporary values. As I just stated the example of live-in relationship, earlier it was considered illegal. Now it is legal. So earlier in the like cases, whatever rules were applicable, can it be applicable now? No, it cannot be. So accordingly, the stand has to be taken. Similarly, can the principle of stare decisis prevent all changes in legal interpretation? Why or why not? Thai ke na thai? No. Why? Because higher courts can overturn precedents to respond to evolving legal, social and policy needs, not on any other basis. Whatever was the judgment of the lower court can be overruled by the higher court, but it also has certain criteria to take care. That is what it means. Next is the structure of Indian judiciary, which you must be much aware of, but as I keep telling, I request again, it is on the basis of this given shared paragraph only. Just a minute. I'm not able to see it, so I'm just trying to kindly bear with it. Just 2 minutes. Okay, yes. As it is the paragraph number 3, Indian judiciary, right? It is talking about the structure of Indian judiciary precisely. As you are already aware that it is talking about Supreme Court, High Courts, District and Subordinate Courts, and then it is talking about Judicial Review and PIL, that you are aware about all these terms. Now, first question in this is, what are the 3 levels of the Indian judiciary? What are the 3 levels of Indian judiciary? તમને આમ જ ખબર છે that what is that, right? Because it is derived directly from the passage. આ તો directly passage માંથી જ ખબર પડે એવું છે, right? And without reading also you can say it. It is just like that. Once again, it is asking about what are the Three, as per the structure of Indian judiciary, what are the three levels of Indian judiciary? So it is Supreme Court, High Court, and district or subordinate courts, depending upon the structure. District na hoy ત્યાં subordinate courts. After that, the second, first to direct છે. Second is also little direct. Why is the primary role of the Supreme? What is the primary role of Supreme Court in India? To act as the final court of appeal and ensure the constitutional compliance through judicial review. Judicial review will come into the picture if we are talking about the primary role of Supreme Court of India. Now, this is inference. Why is public interest litigation PIL significant in the Indian legal system? PIL કેમ આટલી important છે? Because PILs empower citizens to raise issues affecting public welfare, ensuring greater judicial oversight on matters like human rights and environmental protection. NGT એટલા માટે તો છે. I mean, that came into existence because of number of PIL. We should be thankful to MC, Mr. Whenever we say MC Mehta versus Union of India, કેટલી બધી PILs એમાં જ છે. So on a lighter part, but PIL plays a pivotal role, and that's why it is important. Why? Because PIL empowers citizens. Now see the question, why is public interested? Why PIL is important? The question is in simple present tense, and so is the answer, because PILs empower citizens, right? We have maintained the tense over here. Next is also in simple present tense, that how does the judiciary ensure that laws align with constitutional principles. Now here, through the power of judicial review, which allows the courts to strike down unconstitutional laws. Unconstitutional laws છે એ બધા નીકળી જાય છે through the judicial review. That's why judicial review is important, and through that it can be done. Why? As per this given paragraph, right? What challenges does the Indian judiciary currently face, and how are they being addressed? Critical thinking. Right now, what is there? The judiciary faces issues like case backlogs. You all are aware about it, right? And accessibility problems. Steps like digitalization. Now, in many of the high courts, digitalization is there, YouTube live is there. Accessibility. કોઈને એમ થયું કે ભાઈ હું નથી પહોંચી શકું એમ પણ લિંક થ્રુ જોઈન થઈશ, નેટવર્કના ઇસ્યુ છે, નથી સરખું સંભળાતું, અડધું સંભળાય છે, અડધું નથી સંભળાતું, which is more dangerous. So that is also one of the issues judiciary is facing right now, right? Fast track courts are being implemented to address this. થઈ રહ્યું છે, but right now the problems are there. After that, what challenges does the Indian judiciary currently face, and how are they being addressed? That is done. Why do you think that digitizing court records can help reduce case backlogs? Again, applied reasoning on the basis of given paragraph only. તમારા મનના વિચારો ઘણા બધા હોઈ શકે, but right now we are considering this paragraph only, which states that digitization streamlines process, improves accessibility, and reduces administrative delays, ultimately speeding up the case resolution. After digitalization, see, each coin will come up with two sides. Each coin. મને લાગે કે ડિજિટલાઇઝેશનમાં બહુ મજા નથી આવતી, આવું ડિજિટલ કોર્ટ ને એમાં બોલવાનું ફાવતું નથી, નોટ કમ્ફર્ટેબલ. દેટ ઇઝ ઓલ્સો વન ઓફ ધ સાઇડ્સ, બટ એણે ઘણા બધા પ્રોબ્લેમ સોલ્વ કર્યા છે, એ વાત પણ યુ કેન નોટ સે નો ટુ ઇટ, રાઈટ? નકારી ના શકાય. That's why it is like this. After that, it is about fundamental rights in the Indian Constitution. All the articles which you already know from 14 to 32 here, certain articles are mentioned because we are talking about fundamental rights. So the questions from here. Two questions are completely direct, and after that there are questions based on inference or critical thinking or by applying the logic or reasoning. So which article is considered the heart and soul of the constitution and why? Article 32. I know you don't need paragraph for reading it. Article 32 is considered the heart and soul of the constitution because it allows individual to directly approach the courts to protect their fundamental rights. As we already know that for the breach of fundamental rights, directly the filing can be done to high courts, to the Supreme Court. Directly it can be done. This was direct question. Why are fundamental rights not considered absolute? Why it is also not absolute? Because reasonable restrictions can be imposed for national security, public order and morality. National security emergencies are included, right? Emergency can be economic emergency, it can be um, defense emergency, national protection emergency, etc. Pandemic was also a kind of emergency, right? After that, how does the right to equality contribute to social justice? Now, this is not completely, this is not completely direct question. It ensures, this is simple present tense. We are writing the answer. The answer would be in simple present tense that states it ensures equal treatment before the law and prohibits discriminatory practices like untouchability, promoting fairness and inclusivity. It is already given, but we are just going through the just a minute. I think it is not visible on the screen. Is that so? Yes, the earlier paragraph is there, I guess. Okay, now I hope it is visible. Yes, now it is visible. So you can read it and the question can be there. It is for those who are not having it with them. So, after third, it is fourth. What role have landmark judgments played in the evolution of fundamental rights? So, judgments like Keshwanand Bharti. When we talk about landmark judgments, or obviously the first thing would come to mind is Keshwanand Bharti have clarified and expanded the interpretation of fundamental rights to meet modern societal needs. Right? How might the right to freedom of religion help maintain communal harmony in India? Now, this requires critical thinking because it is democracy. India is having democracy and secularism both. So, by protecting the freedom to practice any religion while prohibiting forced conversions, it encourages mutual respect among communities. You have to think on the basis of given passage and make the answer. If a person is unlawfully detained, which constitutional remedy can they seek? They can seek a writ of habeas corpus under Article 32. Article 32, which is considered as the heart and soul of Constitution. Habeas corpus. That is the writ which can be there for unlawful detention. Right? After that, it is Keshwanand Bharti case. I guess from that, it is very easy for you to get it. After that, it is the paragraph about the functioning of Indian Parliament. That is the last paragraph. I'll just go through that because Keshwanand Bharti, I feel that it can be done by a person's own. I guess that is easier comparatively. I'm just checking it out whether that paragraph is there. Yes, this is the paragraph, but it is into two parts. So I'm right now keeping this particular page on screen. I hope it would be visible right now. Okay, because the question would start from what are the two houses of the Indian Parliament and how are their members chosen? Because I know you already know this answer. Even if the paragraph is not there. The Lok Sabha and the Rajya Sabha, right? These two are the houses. Lok Sabha elected directly by the people and Rajya Sabha elected by state legislative assemblies. Now that is direct question because it is already given. Second question, why can money bills be introduced only in the Lok Sabha? Money bill will never be introduced in Rajya Sabha. It will be introduced in the Lok Sabha only. Again, this is a direct question because the Lok Sabha represents the people directly and is responsible for financial matter because the Lok Sabha represents the people directly elected and is responsible for financial matters. Now the question is of inference based, that how does the Rajya Sabha contribute to federation in India? How does the Rajya Sabha contribute to federation in India? So, by giving states a voice in national decisions and ensuring their interests are represented. This is how the Rajya Sabha contributes to federalism in India. Right? Next is, why is lawmaking process divided into multiple stages? This is something you all must be aware of, that judge is not making the laws. Judge is interpreting the laws which are made in the Parliament of India. So here, how does why is lawmaking process divided into multiple stages? Why? Because to ensure through examination, debate, and consensus on proposed laws, means it should not happen overnight. There would be debate, there would be examination, there would be questions, and after that, the proposed law will take the form of a codified law, not before that. How does parliamentary oversight maintain accountability in a democracy? Then what is the process? By questioning the government, reviewing the policies, and scrutinizing the legislation to prevent misuse of power. See, the government can also be questioned, the ruling party can also be questioned, the policies can also be reviewed and questioned, and that's why it can be done. After that, why do you think the Rajya Sabha is a permanent body while the Lok Sabha is not? The Rajya Sabha ensures legislative continuity and stable representation of states regardless of political changes. While in Lok Sabha, there can be the changes based on if the party changes, if Gathbandhan changes, anything can change. Where in Rajya Sabha, it is not like that. That is again on the basis of the paragraph that has been given. Right? So it was about reading comprehension. Along with this, today I'll be sharing the uh, material with the answers itself. Right? Whatever we have discussed with answers, it will be shared, and whatever was discussed yesterday, that is about the statements are given in different frequently used phrases in the field of law, in legal field, frequently used phrases. That material will also be shared today, that PPT. With that, we will be ending it for today for the recording. Once again, I request spare 10 to 15 minutes daily when you sit and you give the exercise to yourself wherein you are thinking in English and you are reading, and whatever you read, try to develop the habit you are reading it aloud. મોટેથી વાંચો, so that વંચાઈ પણ જશે, સંભળાઈ જશે, બોલાઈ જશે. 3 things are already done, and then you already have the practice of noting down, so that would help, and all 4 features would be included. With